Discharge of contracts. Under this topic, you are going to learn about how a contract is discharged, how a contract is terminated. Once a contract is discharged, it means that the parties are no longer bound to the contract. There are no longer contractual relationship between the parties. Before this, you have learned about how to form a valid binding contract. You have learned all the 7 essential elements in order to form a valid binding contract. Now, under this topic, you're going to learn about how to terminate or discharge the contracts. There are 4 ways or 4 modes how to discharge a contract. One is by performance, pelaksanaan contract. Second, by agreement between the parties, persetujuan pihak-pihak yang berkontrak. Third, by frustration, kekecewaan, or impossibility of performance, kemustahilan pelaksanaan. And fourth, by breach of contract, pelanggaran kontrak. So these are the 4 ways how a contract can be discharged or how a contract can be terminated. Okay, now we come to the first mode, how to discharge a contract. That is discharge by performance. Pelepasan secara pelaksanaan kontrak. This is the usual mode of discharging a contract. Of course, once you make a contract, the parties are bound to perform the contract. So once they perform the contract is discharged. If only one of the party has performed, he alone will be discharged and the other party not yet discharged from the contract. For example, let's say A contract to sell his car to B. Under the contract, A has to deliver the car to B and B will make the payment to A. Once A has delivered the car to B, in that case, A is discharged from the contract. On the other hand, if B still has not made the full payment of the car, B is not yet discharged from the contract. He is still bound to the contract to pay the full amount of the price of the car. So that is the meaning discharge by performance, where once you have performed the contract, then you are discharged from the contract. Next is discharge by agreement. Discharge by agreement happen in the form of substitution, penggantian kontrak baru, or alteration, pengubahan kontrak asal, or rescission, penamatan of the original contract. So this is the meaning of discharge by agreement, meaning that the parties to the contract agreed to substitute the first agreement with the new agreement or alter any of the terms of the contract or resign the original contract and come to the new contract. This is by virtue of section 63. However, the discharge, the agreement must come from all of the parties. If any one of the parties did not agree with the rescission or with the substitution of the contract, the agreement is not discharged and they are still bound to the original agreement or original contract. The third one is discharge by frustration. Discharge by frustration atau kekecewaan ini berlaku in 2 situations. First, when the contract itself impossible. Bila kontrak itu sendiri adalah kontrak yang mustahil to be performed. Mustahil untuk dilaksanakan. In this situation, the contract should be discharged by frustration. The parties would be frustrated because the contract is impossible to be performed. For example, under the illustration to section 57, A agrees with B to discover treasure by magic. Of course, this is impossible to be done. It is impossible to be performed. In that case, this agreement, this contract should be discharged, and it is discharged by frustration. The second situation, how discharge by frustration may happen, is that the contract becomes impossible. menjadi mustahil. In the first place, the contract is something which is possible to be performed. It is valid contract. However, because of supervening impossibility, berlaku sesuatu kejadian yang luar jangka. Due to the supervening event, kejadian luar jangka, the contract is discharged by frustration. Here are the examples how a contract become impossible due to supervening event. First, destruction of the subject matter. Kemusnahan perkara yang dikontrakkan. So you can see from the pictures here, okay, where let's say the contract is about a sale of a car, but the car involved in an accident and having total loss. Or maybe the house, which is the subject matter of the contract, was caught on fire. In that case, the contract is impossible to be performed. Supervening event, which defeat the whole purpose of the contract. For example, you can see from this picture, let's say you make a contract to rent a room in an hotel, but the hotel was destroyed due to tsunami. Or maybe you make a contract to install a condition in an office, and then unfortunately the office itself was caught on fire, and of course it defeats the purpose of your contract where you cannot install the air condition in that office. Death or personal incapacity. This is another way how a contract may be discharged because of impossibility of performance. Due to the death of the parties to the contract or his personal incapacity, he cannot perform the contract. The contract should be discharged. Change in the law or outbreak of war. For example, the subject matter of the contract is relating to certain cosmetical product, but unfortunately, the product was banned in Malaysia. There is a new law announcing that the product is not safe. It's very dangerous to the usage of the public. So in that case, the contract should be discharged. You cannot perform the contract because if you still continue with the contract, then it is unlawful. It is illegal. Outbreak of war. Due to the war, the parties cannot perform the contract. It should be discharged. If you continue with the contract, in that case, you are contracting with an enemy. So this is unlawful. And last one, discharge by breach of contract. Breach of contract means pelanggaran contract, where one of the parties fail or refuse to perform the contract. In that case, the other party may repudiate, may terminate, may resign the contract. That is the right of the other party who was not at fault. He can discharge the contract due to the breach of contract by the other party.